All right, so thank you so much for having me here. I'm thrilled to be here. On September 24th, 2018, the Human Rights Tribunal of Ontario ruled that the Ministry of Health's failure to proactively monitor and regularly negotiate midwives' compensation rates constitutes discrimination. In addition to revealing a significant and persistent pay gap, when comparing midwives to professionals performing similar roles, this legal case underlines several aspects of discrimination that speak to the larger issues surrounding the nature of the devaluation of feminized professions in healthcare. In my paper, I initially planned to broadly examine the devaluation of midwifery, with particular attention to the contradictory role of the state when positioned as an employer. However, this long-anticipated recent decision provides vital context for the case of Ontario midwives and feminized healthcare professionals in general, and so it has come to be my focus. That said, the recency of this decision means that my analysis is very much a work in progress. I'm going to start today by offering a brief history of the treatment of midwifery in Ontario, before outlining the scope of the Association of Ontario Midwives' human rights complaint, followed by some analysis of the limitations and possibilities posed by the decision. Before proceeding, a few words on my theoretical influences and framing. My research investigating midwifery, which as a profession is integral to processes of social reproduction, is informed by feminist political economy. Through this lens, I seek to illuminate how and in which ways, under neoliberalism, midwifery has become destabilized and devalued through governing practices characteristic of this era. In this regard, feminist political economy's holistic theorization of the linkages and tensions between sustained capitalist accumulation and social reproduction is highly instructive. This approach also offers insights into the gendered character of welfare state retrenchment, insights that oppose its supposed false neutrality. In an era characterized by constrained public spending and the simultaneous reconfiguration of collective responsibility, I'm interested in whether midwives are absorbing costs of services integral to social reproduction that rightly belong in the domain of publicly provided healthcare provision. In this paper, my analysis of the recent tribunal decision seeks to show how allegedly neutral laws, policies, and regulations contribute to the devaluation of a feminized occupation fulfilling a vital role in reproductive healthcare. Midwifery was once the dominant form of maternal care in Canada. Starting in the early 19th century, however, medical practitioners successfully lobbied governments to deny midwives professional licenses. Home births became stigmatized, and hospital births increased in an effort to legitimize physicians' scientific knowledge and privileged status in healthcare provision. But by the 1980s, many family physicians started to abandon time-consuming and less profitable obstetrical care, resulting in a shortage of publicly regulated pregnancy and postpartum care. When a contingent of midwives with considerable public support lobbied for greater public recognition and integration into the healthcare system in the mid-1980s, the provincial government identified an opportunity to address this chronic shortage. Midwifery was first recognized as a profession under the Midwifery Act in 1991, which legislated midwives as autonomous primary caregivers and determined their scope of practice to include the provision of comprehensive care during a normal pregnancy, labor, and postpartum period. Bringing midwives into the fold of healthcare formally offered the government a cost-effective alternative to high-risk specialists such as obstetricians, providing relatively low-risk pregnancy care. In order to determine midwives' compensation rates, the association and the ministry engaged in a collaborative process and commissioned a rough pay equity analysis. While complex and technical, this approach essentially compared positions relative to midwifery, including high seniority nurses, as well as physicians in community healthcare clinics, which was a historically and at the time male-dominant profession. Referencing the findings of this rough pay equity analysis, the two parties engaged in positional bargaining to determine that midwives should receive approximately 90% of the community healthcare physicians' starting rate of compensation. The examination of this initial process is central to the tribunal's ultimate decision, insofar as it created a framework for preempting and preventing discrimination. That is, for the tribunal, the ministry's eventual disregard for this process is a key indicator of adverse treatment based on a protected ground, that is sex. Despite this initial collaborative process, the government's level of financial support has proven inadequate and inequitable relative to that provided to physicians. After decades characterized by wage freezes and a general unwillingness of the ministry to negotiate regularly with the Association of Ontario Midwives, independent reports prepared by pay equity experts revealed a 48% pay gap when comparing midwives to community healthcare physicians. In 2013, the association filed a complaint under the Human Rights Code, arguing that the ministry, in disregarding the initial comparative framework for setting compensation, systematically devalues midwifery as a work performed primarily by and for women, and which plays a vital role in reproductive health care. In their complaint to the tribunal, the association argued that from 1994 to the present, the ministry violated midwives' right to equal treatment without discrimination on the basis of sex under the Human Rights Code. To make this argument, the association thereby contended that sex is and continues to be a factor in the adverse treatment that midwives have experienced. I will now briefly highlight some of the association's arguments in relation to some key sections of the code. So midwives chose to file their complaint with the tribunal in part because of their independent contractor status. The code defines employment broadly and extends protections to independent contractors and subcontractors. As the association noted, if a party is found to be responsible for a claimant being treated unequally, it will be held liable under the code. This is the case even if the entity is not the claimant's direct employer. In its submission to the application, the association argued that midwives' status as independent contractors is instrumental to the ministry's evasion of certain employer responsibilities. The ministry justifies this status and employment on the basis of midwives' irregular schedules, on-call hours, which are work arrangements that are essential to midwives' comprehensive, low-intervention, and low-cost model of care. Cast as pseudo-entrepreneurs, midwives are also denied protection under a range of provincial labor and employment law and policies, including the Employment Standards Act, the Labor Relations Act, and the Pay Equity Act, which requires that employers take proactive measures to protect highly feminized professions from gender discrimination. As feminist political economists have shown, labor and employment laws and policies that center the norm of the full-time permanent worker with regular hours often inadvertently and sometimes deliberately serve to legitimize precariousness confronting workers, especially those whose employment relations deviate from this standard. Additionally, because the seemingly neutral standard employment relationship actually takes the male industrial worker with national citizenship as status quo, exclusions are highly gendered, racialized, and based on citizenship and immigration status. Arguably, these insights apply here. While historically male-dominant and highly valued healthcare professionals are typically treated as independent contractors, the AOM demonstrated that the associated lack of protective measures has had particularly adverse impacts on midwives and therefore heightened their vulnerability to other mechanisms of devaluation. This includes the steady expansion of midwives' scope of practice, that is, the tasks for which they are responsible, simultaneous to the implementation of constraint legislation. A central and strategic argument in the association's application, then, was that despite the existence of the Pay Equity Act and midwives' exclusion from it, the right to be free from sex-based discrimination in compensation, or pay equity, is a fundamental human right guaranteed by the Code under Section 5. From here, the association also highlighted an obligation under human rights legislation to take up preventative measures to protect vulnerable groups from various forms of discrimination. Unlike complaint-based approaches, obligation holders under human rights law are expected to prevent, identify, and eradicate the mechanisms of discrimination that are likely impacting their employees. The association then offered significant evidence that during and in between formal negotiations with the province since 1993, the ministry was either reluctant or refused to engage with the original comparative framework for compensation that provided parameters for an ongoing, proactive approach to protecting midwives from gender-based discrimination. The association also drew on Section 11 to argue that the imposition of various forms of compensation restraint on midwives since 1994 is an example of how a seemingly neutral rule of general application can have adverse consequences linked to the gender of midwives and the gendered nature of their work. While the ministry argued that its commitment to fiscal responsibility and its various applications of compensation restraint are neutral, there is significant evidence that this practice was historically and remains highly gendered. The key example for the tribunal's purposes was the ministry's response to a joint compensation review in 2009, which called for a 20% increase in compensation for midwives, described as a one-time pay equity adjustment. The review affirmed the 1993 funding principles, including comparisons with the community healthcare physician. The ministry unilaterally dismissed these findings and notified the association it would apply constraint legislation in the next round of negotiations. The government's new Public Sector Compensation Restraints Act was only meant to cover employees and made exceptions for pay equity adjustments and human rights entitlements. The association countered that the constraint legislation should not apply to midwives as independent contractors, especially in the wake of the Joint Compensation Review's findings. The ministry nevertheless froze midwives' pay, citing their exclusion from the Pay Equity Act and noting that community healthcare physicians were no longer a male-dominant profession. This action, alongside other examples offered by the case, reveals how, under the guise of neutrality, the ministry's application of austerity-driven measures can in fact exacerbate polarization. In the end, the tribunal ruled that there is sufficient evidence to prove gender-based discrimination between 2005 and 2013, but not earlier. The tribunal was convinced that after 2005, the ministry unilaterally withdrew from the funding principles established at regulation to proactively prevent discrimination. While the tribunal did not affirm nor negate the principles or the appropriateness of the comparator, it argued that until an expert report proves otherwise, the original funding principles still stand. As the tribunal's vice chair noted, it is difficult to accept the ministry's assertions that midwives and physicians are different, considering that it promotes family physicians and midwives as comparable obstetrical providers, equally competent to care for women with normal pregnancies. Put differently, it's hard to reconcile the state's contradictory interests in, on the one hand, promoting midwifery as comparable to obstetrical providers to save on costs associated with public funding for social reproduction, and on the other hand, simultaneously refusing that similarity in order to contain midwives' compensation rates. These are the paradoxes shaping neoliberal governance, which feminist political economy has revealed to be highly gendered in their effects. The recent decision of the tribunal affirms that the application of compensation restraint legislation compounded the effects of midwives losing their connection to the 1993 funding principles, and therefore constitutes, for the purposes of the code, adverse treatment of midwives on the protected ground of sex. In doing so, it suggests that seemingly neutral policies, characterized as fiscally responsible measures, can in fact be gendered, insofar as they compound the devaluation and exploitation of feminized occupations providing client-led care to feminized and otherwise marginalized patients. Feminist political economy nevertheless provides the ground for a deeper critique. It shows how the withdrawal of public support from services that help ensure a sustainable process of social reproduction necessarily has gendered implications in at least two interrelated ways. First, the withdrawal of public supports downloads such processes onto private actors, such as the family and those traditionally tasked with activities associated with social reproduction. And second, it erodes protections for and further devalues so-called women's or feminized work in the public sphere, as the case of midwifery illustrates so well. In the end, rather than prescribing remedies proposed by the association, the tribunal's interim decision encourages both parties to return to a state of cooperation with the original funding principles as their guide. The tribunal remains seized of the matter and thus available for further interventions, offering midwives a leg up in negotiations, which have historically been characterized by significant imbalances in power. However, the next round of negotiations will take place in a political climate characterized by increasing rather than receding austerity. While engaging in a cooperative process with the ministry offers certain promises and makes space for critical contestation and possible change, these negotiations will still ultimately be informed and shaped by long-standing structural relations of, in this instance, principally gendered power and inequality. Thank you.